Welcome to Civics and Coffee. My name is Alicia, and I am a self-professed history nerd. Each week, I'm going to chat about a topic on U.S. history and give you both the highlights and occasionally break down some of the complexities in history and share stories you may not remember learning in high school, all in the time it takes to enjoy a cup of coffee. Hey everyone, welcome back. A couple of weeks ago, I had the honor of welcoming Dr. Dylan Penningroth to the show to discuss his latest book, Before the Movement, The Hidden History of Black Civil Rights. Leveraging court documents from across the country, Dr. Penningroth demonstrates how Black Americans asserted their civil rights long before the movement of the 1950s and 60s. Dr. Penningroth is a prize-winning historian who specializes in African American history and is currently a professor at UC Berkeley. Our conversation was recorded over Zoom, and we unfortunately did experience a bit of a technology malfunction you may notice towards the latter part of the interview. Dr. Penningroth was so gracious to power through, and my deepest gratitude goes to him for sticking with me. With that, I hope you all enjoy the conversation. Hey everyone, with me today is Dr. Dylan Penningroth. He is a professor of law and history at the University of California, Berkeley, and author of Before the Movement, which will be the focus of our conversation today. Welcome, Dr. Penningroth.
Thank you for having me.
All right, so let's dive on in. You outline in your opening that you decided to write this book as a way to tell a fuller history of Black people and their use of the law. And so how does studying legal history in the 19th century help fill this gap?
So the book runs from 1830 through the 1970s. And as you point out, it absolutely does begin in the 19th century. In fact, in the days of slavery. And the way that it illuminates something different about the history of Black civil rights is in two ways. One, it's that it's trying to tell a story about how Black people used law, thought about law, talked about law. And this is important because I think conventionally what we're taught is that Black people were essentially alienated from law, that the law was an oppressive force in their lives, and that the only thing to do with law was to get away from it. And so just showing that Black people were thinking about law, using it before the great marches, the freedom struggle of the 1960s, changes the way that we think, not only about those freedom marches, but about Black people's relationship to law in general. But the second way that I want to change the way that we think about the civil rights movement, it goes beyond law itself, because once we start thinking about Black people's relationship to law, we have to consider what kinds of law we're actually talking about. For the most part, my book is not about constitutional struggles. It's not about criminal justice. It's not about discrimination. It's about what people in the 19th century used to call civil rights. That is, the right of property, the right of contract, and the right to sue and be sued. That is, the right to go to court. Those were the paradigmatic civil rights of the 19th century. And once we realize that, we can start to ask questions like, well, how did we wind up with a definition of civil rights, both in law and popular culture, that is almost entirely focused on federal courts, the US Constitution, and the principle of anti-discrimination? But then we can also think about many huge swaths of ordinary life that aren't captured by those modern definitions of civil rights. So I'm thinking about things like elder care. What do you do when you get old? How do you navigate that? How do you figure out who's going to care for you? Things like marriage and divorce, inheritance, basic property law. All of these are things that Black people cared about. And when you start thinking beyond the modern definition of civil rights, you can begin to glimpse that. So it's a story about Black civil rights that opens a window on Black life more generally.
Yeah. And you kind of already touched on this in your overview, but your book does provide this kind of new framework for us to understand those civil rights. And you were talking about how, in the 19th century, there was kind of a different definition. And I think some may find that a little surprising. And so can you kind of speak about this more and why you feel like that is really the key portion of understanding this history?
I think it's the key portion for understanding this history because that's what the sources say that Black people thought mattered to them.
Mm-hmm.
I went into county courthouses, and of course, I've also used reported appeals court cases, which anyone can get from the internet. And I looked at those cases, and the overwhelming majority of them were not about race discrimination. Some of them were, and that's obviously an important dimension of the story, and I tell that in my book as well.
Mm-hmm.
But much more common was people doing things like arguing over property lines. And so to be true to the way that Black people thought and acted about law, I needed to expand the definition of law, or really not so much expand it, as to go back to the vision that they themselves held for most of African American history until about the 1940s. Now, there is, as I said, throughout this period that I'm talking about, a sense that race discrimination is wrong and should be opposed. And so that story runs alongside, but it's really kind of in a minor key.
Mm-hmm.
It's not the dominant strain of thinking. And often the two strands of thinking mix together, they interweave, so that even during the height of the civil rights movement, or especially during the height of the civil rights movement, the organizations that push civil rights, like the NAACP, Legal Defense Fund, the Southern Christian Leadership Conference, the Montgomery Improvement Association, all of these really famous civil rights organizations and their leaders are really, really depending heavily on what you might call old school civil rights.
Mm-hmm.
They make contracts, they lease property, they rent offices. Martin Luther King and his team, they go out and protect Martin Luther King's name, image, and likeness, his NIL. Right? He doesn't want from people who are making bootleg recordings of his speeches. So, those sorts of things mattered, and they are actually a part of the story of modern civil rights, the so-called freedom struggle. And that, I think, deserves to be told in a way that that elevates both strands of the story.
Yeah, I think what was striking to me so much was just through the everyday use of the legal system, whether it was suing over property lines or so on and so forth, that there was this underlying assertion of having rights and being a part of the legal system. And I think you interweave that story so so wonderfully. So definitely such a striking definition of kind of really reorganizing someone's thoughts about what it meant to fight or to assert civil rights. And so kind of starting with the beginning of your book, you start by reviewing slave privileges. And so can you expand on what these were and how they fit into your legal argument?
It's a great question. So I'm thinking back to the beginnings of when I got interested in this topic. And it really, comes out of family stories. And one of the family stories that I heard a lot was about my great uncle, who was named Jackson Holcomb. He was an enslaved man in Virginia, and he had a boat. So his son, Thomas Holcomb, was telling my uncle about this boat that Jackson Holcomb had. So he has a boat. And when the soldiers of the Confederate Army lose the Battle of Richmond, they end up retreating through Cumberland County, which is where my family's from. And some of them come up to Jackson Holcomb, and he ferries them across the river. And then when they get to the other side, they paid him. And that struck me as being a remarkable detail. Why would these, you know, literally white supremacist soldiers fighting to preserve slavery, obviously hungry, tired, and well armed, why would they pay a black man, an enslaved black man, for anything? They could have just taken his boat or taken the ride for free. And what I think is going on here is that white people across the South were used to seeing black people have property, and they were used to making deals with enslaved people. Deals like, take me across the river and I'll pay you a little bit of money. Or deals like, if you finish your work before sundown, then you may go to your cabin or to a special field and you can work and keep the proceeds of that work and use it to feed yourself. So there are these trade-offs that slave owners and ordinary white people are making with enslaved people all the time in the South. And what that gives to enslaved people is not rights. So Jackson Holcomb, my ancestor, could not have gone to court and sued if those soldiers had taken his boat. But he had the privilege of running a boat, and he had the privilege of making deals. And that word privilege sounds kind of like a weak, sort of not very important prerogative. But in 19th century law, it actually mattered a good deal. The word is actually in the Constitution in Article 4, the Privileges and Immunities Clause, the privileges and immunities of citizens. And so in the 19th century, people would have understood the word privileges as being something closely related to rights. Not quite the same thing because you can't go to court to defend it, but nevertheless, it has a kind of social power within the limited community of people who are around you and understand the social networks in which people move. And so that is the beginning of the story of Black people's relationship to law. And what's really interesting and maybe surprising about this, what it means is that when slavery ends, that's a radical transformation. But what's not a radical transformation is for Black people to own property, to have property rights and contract rights. So that, I think, is a continuity that I think, I found fascinating when I first started figuring it out.
Yeah, and you describe it so well. I remember kind of going through that section of the book and really having to kind of pause for a moment, like, oh wow, no, that makes that while you wouldn't think of that as a conventional argument, it made sense as you laid it out. So yeah, it was a great portion of the book.
I appreciate that.
And so moving forward, what role did associates play in establishing a legal existence for Black Americans?
So I'm glad you brought that up. So the law of associations is this, it's an important and related part of the story. So an association is essentially any collectivity that bands together to accomplish some purpose. Many associations back then and today decide to incorporate. You go to your local courthouse, you file some papers, probably you'll hire a lawyer, but it really doesn't take that much to incorporate. And the reason these are important is because so much of Black life in the 19th century either runs through associations or is influenced by associations. So if you think about something like Black churches, obviously a hugely important part of African American history. Well, Black churches are associations. They're religious associations, and many of them then and now are incorporated religious associations. So Dexter Avenue Baptist Church, where Martin Luther King preached, Ebenezer Baptist Church, where his father preached and King preached later, they're both corporations. One of the first corporations formed anywhere in the United States was Bethel African Methodist Episcopal Church in Philadelphia. Sally Gordon at Penn has uncovered the fascinating story of how and why they decided to incorporate. So religious associations are important. There are business associations. There are labor associations, something like a labor union. And all of these matter a great deal to Black people. They also generate these um, these important questions about identity and obligations, because at various points in an association's life cycle, people will inevitably raise questions that go something like this: what is this collectivity for?
Mm-hmm.
Like, what is the church for? Is it for worshiping God, or is it for something else? Like, for example, well, everybody knows you go to church to socialize, um, but does it also have a duty to the race? Should the church get involved in the civil rights movement? This was a burning question in the 1950s and 60s, not just because they knew that white supremacists, the KKK, might show up and burn the church building, but also because many people sincerely felt that a church is for worshiping God and cannot get mixed up with the affairs of this world. And so these questions come up again and again. Now, white churches have the luxury of standing off to the side and making the decision that a church is just for worshiping God. But Black churches can't, because they are being excluded and subordinated continually by white people. They're excluded from white churches, for example. And so there's this long tradition, this long sense among African Americans that any association that they form has some kind of duty to the race, however vaguely you want to think about it. And so these questions come up again and again, and inevitably they lead to clashes over property, over the management of finances, like who's building, who does the church building belong to? Who do the assets of the corporation belong to? Who gets to choose the minister? Can a president of a corporation serve for the rest of his life? Who gets to pick the board of directors? And these questions are constantly being asked. And to bring it back to the question we talked about at the beginning with respect to slaves, the members of a corporation, like a church, they are widely understood legally and socially to have privileges but not rights.
Mm-hmm.
And so the members of a church, for example, a Black church, which is mostly women, they don't actually have, or at least it's an open question as to whether they have any kinds of rights in the church at all. Do they have the right to the church building? Do they have the right to hire and fire the minister? The answer consistently, almost always, is no.
Mm.
There are no women preachers. They don't get called. God doesn't call them somehow. Men occupy the pulpit for decades at a time. And so this question of members' privileges versus members' rights vis-a-vis the authority of leaders, it's an ongoing struggle that's occurring within Black associations at the same time that they are struggling against white supremacy.
And kind of speaking about the associations and how they participated in the law as well, kind of more broadly speaking, what are some of the ways that Black Americans influenced the evolution of the law?
Oh, that's a great question. So when we're thinking about associations, the one that springs to mind is a case called Bolden versus Alexander. It was quite famous in its time. It was decided in 1872. And it's basically a case about the private law of religion. It's kind of First Amendment, as well as a question about property. And it's a companion case to an even more famous case that involves a white Presbyterian church. But basically, the gist of it is that courts can intervene in a church fight, but only if things that are not about theology are involved.
Mm.
A court can wade in on questions of what the court calls civil rights. Again, property, contract, right to sue and be sued. Those are the places where a court can intervene. And this is enormously important, of course, because today, you see all sorts of churches, especially white evangelical churches. Their leaders are doing things that many members disagree with. For example, leading them headlong into the modern Republican Party,
Mhm.
um, preaching right-wing politics from the pulpit. Not everyone in these evangelical churches, these white evangelical churches, is on board with that. But what remedy do they have?
Right.
Well, cases involving Black churches are still good law being cited today for that very proposition.
Mm.
Um, just to take another quick example, if you go to law school and you take a contract law class, you will take a contract law class in your first year, you'll open the case book. There'll be an assigned case book, maybe 1,200 pages long, and you'll work your way through it methodically. And by the time you come to the end of the year, you will have probably spent 20 minutes discussing one case that the professor indicates involves an African American. It's a case about unconscionability called Williams versus Walker Thomas. We don't need to get into what that is. The point is that there's only one case. You can go through your first year of law school, and there's one case in your contract law class where you know it's a Black person. But it's not the only case where Black people are involved. And that's because these case books contain something like at least 2 or 3 more cases involving Black people, but you don't know it because any reference to race has been stripped out somewhere in the editing process. So I try to talk about why that is, why the cases are still there,
Right.
and why these cases don't say anything about the race of the parties. So there's a really interesting way that the law, like something like contract law, is actually colorblind, just as Chief Justice John Roberts says, but only superficially.
Yeah.
Like it's you have a case involving a Black person where the facts of the case really matter, but the judges or the case reporters took that fact out for reasons that have everything to do with race.
And you discuss the relationship between lawyer and client and expanding access to the law. So can you kind of get into that a little bit more and explain kind of how that led to this further evolution of access?
Sure. So in 1866, Congress passes the Civil Rights Act, the first national civil rights act guaranteeing African Americans or guaranteeing all persons in the United States the right to property, contract, and the right to sue and be sued regardless of race, color, or previous condition of servitude. And so you have now 4 million new citizens of the United States and of the state in which they live. So citizens of Virginia, citizens of Georgia, South Carolina, and they now become a potential market for legal services. You got all these white lawyers in the South, and they're always looking for clients. And lo and behold, Black people need someone to write up a will for them or to write a contract for them. And they start to hire lawyers. Many of these white lawyers who get hired in the 1860s, 70s, 80s, 90s, many of them are most of them are white. Many of them are ex-Confederate soldiers. Some of them are not just sort of passively white supremacists, but actually took an active role in pushing segregation in their state legislatures. One of the lawyers who represented Black clients shot another white man just for suggesting that he had Black ancestry. So these are not cause lawyers. They're not out there trying to sort of push the idea of racial equality. But what they do care about is money. And black clients are good business. In fact, they're such good business that some of the elite white lawyers band together in the 1890s to push out black lawyers, to make it impossible for black lawyers in the South to practice law. Again, why did they do that? They wanted the business, including business from African American clients. So these kinds of interactions turn out to be really fascinating. You've got these white supremacist lawyers and you've got black clients. How do they relate to each other? It's obviously an incredibly unequal relationship, not just because black clients have nowhere near the knowledge of the law that lawyers do. That's true of white clients as well, but also because of the reality that black clients tend to come to the table on average with fewer chips. They come to, if pre-trial bargaining, right, is kind of a game, black people have fewer chips that they can put in the game. So they don't have ready cash on hand that they can pay a lawyer up front. And so lawyers are more likely to take it on contingency, if at all. It's hard for them to hold out if, say, the person on the other side of the contract says, take it or leave it. Well, often they just have to take it because they can't hold out. They have to feed their family, put groceries on the table. But white lawyers, again and again, go to bat for black clients. And sometimes they take cases up to the Supreme Court of a state or even the Supreme Court of the United States. But in the process of doing so, two interesting things happen. One is they use race opportunistically. So sometimes they'll talk about their client's race because they think that it's going to help the client's case. So they sometimes portray clients as being helpless Negroes, ignorant Negroes. And the reason they're doing that is because that's a winning argument or a potentially winning argument. You can get out of a bad contract if you make that claim. At other times, they take race out. And sometimes that's because they want to set a precedent that will be binding not just on cases involving African Americans, but on any person who's bringing a similar kind of claim. So white lawyers do that sometimes. They take race out because they want it to cut wider. And sometimes Supreme Court justices do the same thing, including people like James McReynolds, who's possibly the most virulently racist man ever to sit on the United States Supreme Court. He takes race out of a case involving a black man precisely because he wants his opinion to bind all cases, no matter whether they're black or white. So there's a story that's really interesting about black lawyers and white lawyers and judges and the clients that they're involved with. And I think that story is incredibly fascinating and not very well known.
Yeah. And we're skipping ahead a little bit, but the Jim Crow era is notorious for its legal discrimination against Black Americans. But you highlight how Black Americans continue to utilize the law, especially tort cases, to exert their rights. So how did they ensure these cases were successful, and what did it contribute to the larger push for civil rights?
Sure. So as we were talking about earlier, African Americans, when they become citizens, they have rights of state citizenship, which include rights of property and contract and standing. But not only that, the Southern economy kind of needs Black people to have rights of property and contract and standing. So if you think about it, the sharecropping system that we know so well, and that is kind of like a hallmark, probably the one thing that everybody knows about the Jim Crow era, besides those segregated water fountains, is that Black people were sharecroppers. Well, sharecropping is a contract. It's an incredibly lopsided contract, but it is a contract nonetheless. And when you sign one with a Black person, you are signifying that you understand that person as being a citizen with the right to make contracts. So the question during Jim Crow is not, do Black people have civil rights? The question is, when you're negotiating with Black people through the language of civil rights, through the law of property and contract, who's going to come out on the short end of the stick? Usually that's Black people, but again, that's because they come to the bargaining table with fewer chips uh, on their side of the table. So white people need Black people to have rights. Now, when I say that, you might be sort of thinking that's kind of a radical thing to say, and it is. And I'll sort of spice up the radicalness even more by pointing out that when I say that, I'm drawing on critical race theory.
Mm.
It's Derek Bell's interest convergence idea. And what he means by that basically is that progress for African Americans in law tends to occur when it's good for white people too.
Mm.
And so civil rights of property and contract are afforded to African Americans during Jim Crow precisely because it's in white people's interests for them to have access to the rights of property and contract and the right to go to court. And so this is, I think, sort of the headline that should be blared up top when we think about the history of Jim Crow, because it's so relevant to what we experience today, right?
Right.
We all have rights of property and contract, but that doesn't make us rich.
Yeah.
It all depends on what, how big a pile of bargaining chips we have when we come to the table. How long can you hold out
Right.
when a boss makes you an offer to settle a suit? How long can you hold out for a better job? These are questions that African Americans thought about, not outside of the law, but right in the heart of what kinds of law mattered to everyday people.
Yeah. And shifting to more of your research methods, one of the things I was incredibly impressed with is the fact that the hunt for your primary source material spread far and wide. You were in county courthouses across the country. And I know that there were some challenges. So I'm curious, what were some of those that you experienced, and how did you kind of navigate that in trying to build this legal history?
Oh, I'm glad you asked that. I guess the first challenge is that a courthouse is not an archive.
Yep.
It's a courthouse, and their job is not to, serve historic documents to a researcher. Their job is really to process traffic tickets, and maybe to help title searchers go through deeds. So, uh, how did I do this work? What I would do is I would hop on a plane, or I'd get in the car and I'd just start driving. I'd drive south from Chicago down I-55, and I'd end up at the end of the night in a place like Cairo, Illinois, down at the bottom. I'd head on down to Mississippi, and at each county seat, I would park downtown and I'd go into the courthouse and I would ask, do you have any old court documents? And I would describe them. They're these big, heavy ledger books. They weigh each probably, maybe like 10, 15 pounds. And usually they would say yes, or I don't know. I would sometimes be able to sweet talk my way into letting me into the basement or the back room or the attic where they kept all the good stuff. And so I would go in, and what I did is I took a sample. So I'd open up these docket books, these big ledger binders, and I would copy down, or more likely I would photograph and then copy down later, every 10th case or every 20th case. And then once we copied those down, me and my research assistants would look them up in the census.
Mm.
Now, you might be wondering, why would we look them up in the census? Well, that's because these docket books did not say what race people were.
Mm,
So, I mean, that's kind of surprising. You think about,
right.
especially during the Jim Crow years, you're in Mississippi, you open up these legal documents. Why aren't they telling you what race the people are? But there's another story about that. But for my purposes, it created a practical difficulty, and Ancestry.com turned out to be the solution. So we looked up each one of the names who were listed on the docket sample that we collected. It ended up being 14,000 cases or so. So something like 25 or 28,000 names that we looked up. And then once we had an idea of which of those cases involved at least one African American litigant, then I would take a list back to the courthouse and I would go and find the loose papers, hoping that there was testimony behind that case. And often there was. And the testimony is what forms the basis of the book. The numbers kind of sketch the big picture.
Mhm.
That's how I can say things like African Americans routinely went to court. It sounds like such a simple thing to say, but a lot of research went into being able to make that statement confidently. But more importantly, it allows me to tell stories.
Right. Okay. So as we kind of look into the totality of the book, what are you hoping readers take away from your scholarship?
Yeah, that's a great question. I guess a couple of things I hope readers take away. One is I hope that when readers finish the book, they'll have a deeper appreciation for the diversity of Black life alongside the commonality of racial oppression. There really is, I think, an important payoff to be had when we think about Black history as being something more than race relations. Because it seems to me that a lot of African American history, when it gets written as the history of race relations, it's almost as if you can't write Black history without a white person somewhere in the picture.
Mm.
And I think that that isn't the case. And I think that there are ways to tell stories that center on Black people, that put Black people at the center of our own history. So that's the first takeaway. And I guess the second one is just to think that, when we talk about the law, we're not talking about one thing. We're talking about the US Supreme Court, but we're talking about your local judge. We can also say that something like when we talk about law, we're talking about something that enables white supremacy, but also enables Black patriarchy. And so that's, I guess, the second lesson. And then the third takeaway is that it's something that occurs to me, especially in the wake of the string of police killings that galvanized the Black Lives Matter movement. And that is that police violence can coexist with Black people using law. Right? That there's a way in which when we think about police violence, that is sort of an oppositional relationship to law. By definition, it's people, police committing illegal acts against African Americans and shoving them outside the law. But at the same time, Black people today, as during Jim Crow, are continuing to use all sorts of different kinds of law, not just to fight back against police violence, but to rent cars, rent houses, travel on airplanes. All of these things involve law. And when we think about Black people's relationship to law in the Jim Crow era and at the beginning glimmers of the civil rights movement, one thing we know is that Black people put their faith in law in the 1950s. And we should not take that for granted. We should be asking, why did a people who had been in so many ways mistreated by law decide to put their faith in law? And I think that question is especially important now because one of our two major political parties, the Republican Party, is actively undermining the rule of law.
And where should readers go when they've finished your book and they want to learn more?
Oh, goodness. I would say if you go to the website of the American Society for Legal History, there are enormous numbers of historians who are doing incredible work. And if you just look up any of their names on the program, you can find amazing, amazing stuff there.
And where can people find more about you and your scholarship?
At dylanpenningroth.com. It's a long and complicated name, but Google has a way of finding us one way or another.
Definitely. And is there anything that we haven't covered yet that you want to highlight for future readers?
I think the only thing that we haven't covered yet that we might highlight is just to think about that readers might consider the ways that law is really all around us, including at your local county courthouse. And there are so many more stories that are left to tell.
Perfect. What a perfect way to end. And so for my listeners out there, be sure to pick up a copy of Before the Movement. Not only is the book wonderfully written, it provides readers with a new lens with which to understand civil rights, legal, and Black history, and it will not disappoint, I promise. Thank you, Dr. Penningroth.
Thank you.
Again, my sincerest thanks to Dr. Penningroth for making the time to chat with me about Before the Movement. If you want to learn more about him, the book, or his other work, be sure to visit the website where I've included links to the websites mentioned during the interview. Thanks, everyone. I'll see you next week. Thanks for tuning in, and I hope you enjoyed this episode of Civics and Coffee. If you want to hear more small snippets from American history, be sure to subscribe wherever you get your podcasts. Thanks for joining me, and I look forward to our next cup of coffee together.